Hello everyone, so I'm back with another case law video. In today's video, I'll be discussing about a recent case that is Rupesh Manger versus State of Sikkim, in which Supreme Court observed that standard of proof to prove insanity is only a reasonable doubt. Before proceeding with the facts of the case, let us first understand the concept of insanity. There is a well-established principle that is actus non facit nisi mensit rea, which in literal sense means that an act does not make the offender liable without a guilty mind. Intention or guilty mind of the offender is an integral part while committing the crime. The defense of insanity is a law that protects the person who is incapable of understanding the nature of the act done by him. Insanity are of two kinds, legal insanity and medical insanity. Legal insanity refers to the mental state of the person at the time of commission of the crime, whereas medical insanity is entirely dependent on the medical grounds. Under the Indian law, insanity is provided in accordance with Section 84 of the Indian Penal Code as a defense. So, in order to claim a defense under Section 84, the following conditions must be fulfilled. Number 1, an act must be done by a person who is of an unsound mind. Number 2, such a person must be incapable of knowing the nature of the act or the act is opposed to law or that the act was right or wrong. Number 3, such incapacity must be by the unsoundness of the offender's mind. Number 4, incapacity must exist at the time of commission of act constituting the offence. It is to be noted that not every form of insanity is recognized as a sufficient excuse by law. So in this case, the bench of Justices J.B. Pardiwala and Prashant Kumar Mishra observed that an accused who seeks exoneration under Section 84 of the Indian Penal Code has to prove legal insanity and not medical insanity. The court observed this while acquitting the accused by allowing his appeal. In this case, Rupesh Manger, who was convicted by the Sikkim High Court after reversing his acquittal by the trial court, he was accused of killing his grandfather. The trial court observed that the accused was incapable of knowing the nature of his act by the reason of unsoundness of mind, and it is highly probable that he was unaware of the acts he was doing was either wrong or contrary to the law. In appeal, the bench was referring to the medical evidence of the mental illness of the accused and his abnormal behavior at the time of occurrence, observed that the view taken by the trial court was perceived or that it was based on without any evidence. The court also said that if the conclusion of the trial court is a plausible one merely because another view is possible on reappreciation of the evidence, the appellate court should not disturb the findings of the acquittal and substitutes its own finding to convict the accused. Thus, the court has held that an accused who seeks exoneration from liability of an act under Section 84 of the Indian Penal Code has to prove legal insanity and not medical insanity. Since the term insanity or unsoundness of mind has not been defined in the Indian Penal Code, it carries a different meaning in different contexts and describes varying degrees of mental disorder. A distinction is to be made between legal insanity and medical insanity. The court is concerned with the legal insanity and not with medical insanity. Therefore, the Supreme Court acquits the man accused of killing his grandfather.